Hello, all, and welcome to today's special Title IX webinar on the 50th anniversary of the passage of the law. Title IX, the 50th anniversary primer, Time to Sue. Today we'll be covering several topics related to Title IX, including the history of Title IX, participation, financial aid, the NCAA, and NIL. Today's speakers are the leaders of the Bailey Glasser Title IX team, including Arthur Bryant, the former chairman and executive director of public justice, who was the lead trial counsel in the first Title IX case tried against the university for discriminating against its women athletes and potential athletes, and who was named a 2021 National Law Journal Sports Law Trailblazer, among many other accolades. Our next speaker is Carrie Joshi, who is a partner at Bailey Glasser and the practice group leader of our commercial and environmental litigation group, and a former NCAA Division I soccer player. Our final speaker is Lori Bullock, who has won high-profile settlements for female student athletes across the country, and who recently won an appeal in the Sixth Circuit Court of Appeals on behalf of swimming and diving athletes. Arthur, Carrie, and Lori have, within the last year, successfully advocated for student athletes at Clemson University, Brown University, and many others. Our speakers are happy to answer any questions you have during the program, time permitting. Please submit them to questions@baileyglasser.com. We will be presenting some slides during the program. If you can use the slider in the middle of your screen to make them either larger or smaller. And with that, I will turn it over to Arthur Bryant to kick this off. Arthur?
Hi, everybody. It's great to be with you, and thank you, Justin, for the introduction. 50 years ago today, Title IX became law. People seem to have some sort of a misconception that it might be tricky or complicated. It isn't. It's a very simple, straightforward law, and it is a civil rights law. This one slide has the entire substantive content of the law. This is it. It's 37 words, sorry, and it says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Now, what that means is that in addition to applying to a whole bunch of public schools throughout the country, Title IX applies to all colleges and universities throughout the country, or I'd say almost all, because almost every college and university in this country receives federal financial assistance. Even if it's just one student there with a Pell Grant, they've got financial assistance, so they're covered by Title IX. So before I turn with you to exactly where we stand after 50 years, let me just give you a little history and background. Back up a second, Justin, please. This statute, when it was passed in 1972, has had an enormous difference, made an enormous difference since. To begin with, when it was passed, there were entire schools, graduate schools, medical schools, law schools, closed to women entirely. There were graduate assistant positions closed to women entirely, or with a small number that allowed into the program. There were math and science programs closed to women entirely. All of that has changed. So a difference outside the arena of athletics has been really quite extraordinary. In the part, however, that's gotten the most public recognition around Title IX has been athletics. And the reason is that athletics is the sole area in education where there are entirely separate programs for men and women. And there, the principle is clear. If you're not going to have any sex discrimination, and the programs are entirely separate from men and women, then what Title IX's regulations and the law says is they have to be separate and equal. That's the principle. It's really pretty simple. If you went with your gut and said, would the men in the men's program and the women in the women's program voluntarily choose to switch positions and be just as happy in the other's program, then you've got equality. If they wouldn't, you probably don't have equality. But I'll walk you through it in a little bit more. But I wanted to tell you in terms of the history being made is extraordinary in most of the areas, and there has been significant difference in athletics. But where we stand now, 50 years later, is really quite extraordinary. Jason, if you can go to the next, Justin, if you can go to the next slide. Where we stand after 50 years in intercollegiate athletics. The sad truth is that almost every college and university in America is violating Title IX at this very moment in its athletic programs. Almost every varsity female athlete in a college or university in America has a strong Title IX claim. So do some male athletes. And all student athletes and potential athletes need to know their rights, and we need to help them for justice to be done. Now, let me review a little bit of the history here and give the overview. From 1972, when the statute was passed, to 1998, there was an argument about whether Title IX applied to athletics. And the reason is, if you go back one slide, Justin, the language of the statute says discrimination under any education program or activity receiving federal financial assistance. And so for the first 16 years, some schools argued, well, my athletics program didn't receive any federal financial assistance. Maybe my athletic financial aid program did. So my athletic financial aid might be covered by Title IX, but not the rest of the athletics program. And in 1984, in a case called Grove City versus Bell, the United States Supreme Court accepted that argument. It wasn't an athletics case, but they still accepted the argument that the specific program or activity had to receive federal funds for the statute to apply. And in 1998, Congress passed the Civil Rights Restoration Act of 1988 and said, no, no, no. If any program or activity receives federal financial assistance, the entire school is covered by Title IX. So go back forward a second, Justin. So in 1998, that's when the real enforcement of this started, and it was by women and athletes, but primarily women athletes. And this is where we stand after 50 years with all that. But let me give you another sort of brief history of the history of enforcement. The United States of America has never filed an action in court to enforce Title IX against any athletics program. All of the enforcement has been done by women and men, male athletes or potential athletes. So in 1998, the Civil Rights Restoration Act passes. And in 1998, I'm sorry, I said 98. In 1988, the Civil Rights Restoration Act passed. And I was the lead counsel in Haffer versus Temple University, the first case against a school for discriminating against its women's athletes. We tried the case for 3 weeks. After 3 weeks, Temple agreed to settle and agreed to treat its men and women equally. And then anytime a school would eliminate a women's team, either I or the National Women's Law Center, who I worked with as co-counsel in that case, would get a call. And I would go threaten the school and say, look, right now, if you just put the team back, my clients will be happy, pay our fees, we go away, and you're done. But if you make me sue you, it'll be a class action on behalf of all the women athletes and potential athletes in the school for all of the ways in which you're discriminating against athletes in the school and potential athletes. It'll cost you a fortune to treat women as well as men. It'll cost you a fortune in your attorney's fees. And you'll have to pay our attorney's fees because Title IX says if you lose, you pay us. Just put the teams back. School after school did that. Sometimes we'd have to get a court order requiring them to put the team back, but then the school would settle. And the number of schools, it was remarkable, including, for example, UCLA, swimming program, other places. But that's how it went until 1992, when Brown University said, how dare you accuse us of sex discrimination, and decided they wanted to fight all the way. We got a preliminary injunction preserving the 2 women's teams it was trying to eliminate. They appealed. The Court of Appeals ruled in our favor in every single legal issue, making new law all around the country because there was really no case law before that. We went back towards trial. On the eve of trial, Brown University decided it would settle and agree to treat men and women equally, but it still wanted to fight about equal opportunities to play sports. So we tried the case against them. At the end of the trial, the judge not only forced them to keep the 2 women's teams they were trying to keep, it forced them to upgrade from club to varsity status several other women's teams. They appealed again. Again, we won every single legal issue. and they asked the United States Supreme Court to take the case. And they said in their papers, if the U.S. Court of Appeals for the First Circuit is right, and Brown, this liberal institution, is in violation, then all of the schools are in violation. And they got amicus briefs from a whole bunch of other schools saying, that's right, if Brown's in violation, we're in violation. And we said, well, yes, they are all in violation, don't even need to hear this case. And the Supreme Court refused to hear the case. So in 1998, we settled with Brown basically agreeing to comply with Title IX in a bunch of ways. And we went on, and I will tell you from basically after, oh, and I should say the head of Brown, the president of Brown, was named by Ms. Magazine the winner of the Male Chauvinist Pig of the Year award. After that, when a school would eliminate a women's team, and I would go to them and say, you have a choice, you can either get into compliance with this law voluntarily, it's a federal law, or you can be like Brown University, which not only had to fight for years and lost, but we've been told they're spending $3 million more a year on their own women's athletic program than they were before. We're told they paid their lawyers $3 million or more, and we know they paid us $1 million more. Do the right thing. And school after school would do that, but very quickly, starting in 2000, schools just stopped eliminating women's teams because they were buying a lawsuit. And that's how it went until 2020, when incredibly, June 2020, Brown eliminated teams again. We went back and sued them again. We got the 2 women's teams reinstated. And since 2020, in the last 2 years, we've gone after 10 different schools, eliminated women's or men's teams that we threatened with lawsuits and got them reinstated and got the schools to agree to comply. But the problem is the schools have learned don't eliminate teams, particularly women's teams, or you're in trouble. And we're still sitting here with almost every college and university in America violating Title IX because most students don't know their rights and know whether or not a team is eliminated, their rights are being violated, they're entitled to equality and aren't suing. So we want to make sure people know the facts so they can see whether it's time to sue. So let's move on. Applying Title IX to athletics. The law is interpreted and enforced by the United States Department of Education's Office for Civil Rights. And the law says that schools must provide males and females with 3 things. First, equal participation opportunities. Second, equal athletic financial aid. Third, equal treatment and benefits. Team comparisons are relevant, like how the men's basketball team and the women's basketball team are treated. That's relevant, but the focus is not team to team. It is, are the men as a whole treated equally to the women as a whole? So let's get into the details first on equal participation opportunities. The Office for Civil Rights in 1979 set out a 3-part test. If you're in compliance with any one of these 3 parts, you're providing equal opportunities. But the key is the first part, and I'll go into why in a second. The first part is the numbers of male and female athletes are substantially proportionate to the respective enrollments, or in plain English, if women are 60% of the undergraduates, women should be 60% of the athletes at the school. You are allowed a little gap, and what that gap is, so it's not perfect proportionality, it's substantially proportionate. And I'll review the language in a second, but basically what it means is if there is a gap between perfect proportionality and where you are, such that another viable team could be added for women, then you're not in compliance with Part 1. If the gap is so small a team couldn't be added, then you are in compliance. Now there's a second way to get there. If you're not proportional, but you have a history and continuing practice of expanding participation opportunities, responsive to women's developing interests and abilities. And I say women because the underrepresented sex at almost all schools are women, except for maybe at Vassar or a couple places like that. The problem is, they said they put this in because 50 years ago, schools had to add a whole bunch of sports before they could get to proportionality. Now, 50 years later, there is, I believe, no school in this country that can legitimately claim Part 2 is really what they're complying with. Because if they've been trying for 50 years and they have a history of continuing and expansion and haven't reached proportionality, there's a significant problem there. And the third way to comply is the institution is fully and effectively accommodating the interests and abilities of the underrepresented sex, which means basically, look, if they say, look, we're not proportional, but we've offered all of the teams here that women have the interest and ability to play, and it's true, you can't blame the schools, so that's compliance. But the reason I say so, almost all the schools are in compliance is, almost all the schools are in violation, is because very few schools have enough teams and enough opportunities for women that they're complying with Part 3. If you check your schools and see what teams are there, which teams could be added that women could be playing on and would have the interest and ability. If there are some, they are not in compliance with Part 3 of the test. So it all boils down to Part 1 of the test. Are the percentages matching? And then obviously if they eliminate any team, well, they're not meeting Part 2. They don't have a continuing process of expanding opportunities because they just eliminated a team. They're not meeting Part 3. They're not fully and effectively accommodating all the interests because they just eliminated a team. So they have to be proportional or they're not in compliance. So Justin, what is substantially proportionate opportunities? For Part 1, it's what I said a minute ago. Is the gap between what the school is providing and what it would need to provide to achieve exact proportionality big enough to field a team for which interest, ability, and competition exist? The key question is whether the number of opportunities required to fill that gap would be sufficient to sustain a viable team, a team for which there is sufficient number of interested and able students, enough available competition to sustain a team. If the school is not proportionate, and there is a gap big enough for a viable team, then unless they're already offering all the women's teams that are available, and there's and there's interest and ability to fulfill, they're in violation and not providing equal opportunities to play sports. So what about equal athletic financial aid? The law is that they must basically provide scholarships in proportion to the number of athletes. That is, if women make 60% of the athletes, they should be getting plus or minus 1 percentage point of 60% of the athletic financial aid dollars. It's a straight number crunch. That's all it is. It's math. And you can go on the web. This information is posted and see if the school is in likely violation or not. Third area, equal treatment. This is the one that's sort of theoretically fascinating, but in reality, crystal clear. The law basically says men and women have to be treated, men as a whole in all the teams, all combined together, and the women as a whole in all their teams, all combined together, need to be treated equally in all of these areas and more. So, equipment, supplies, practice, travel, coaching, compensation of coaches, locker rooms, facilities, you name it. And so in theory, a school could treat the men way better than the women in equipment and supplies, and the women way better in locker rooms and facilities, and it could wash out. Or it could treat 110 men football and basketball teams like gods, and the women, and the rest of the men is dirt. And all of the women in between, and it could all wash out. But that's not the reality. The reality is, in almost every school in this country, the men's football team and basketball players, around 110, are being treated really, really well. Maybe the women's basketball players are being treated almost as well. The men on the rest of the programs are generally being treated just as well or better than the women on the rest of the teams. So the men as a whole are being treated way better than the women as a whole. And as a result, almost every school in this country is in violation of Title IX in terms of treatment. So let's talk about the bottom line, first of the law. In participation, women's and men's athletic participation and undergraduate enrollment rates must be so close that a viable team won't fit unless the school is already offering all viable teams for the underrepresented gender. In athletic financial aid, dollars must be within 1% of athletic participation rates, and in treatment, there needs to be separate and equal overall the men's and women's teams. But I want to address one other aspect of the bottom line because people keep asking me this question. And that is, what about money? And the truth about money, Justin, if you'll move on to the next slide for a second, is money for Title IX does not matter. Whether teams or programs make or lose money doesn't matter. Whether teams are revenue producing doesn't matter. That's a great term they use. They say football is revenue producing. The truth is, it might bring in revenue. 95% of the football teams in this country are losing money. Calling them revenue producing is a joke. It's just a term to make that sound better, but they're losing money. But the law is, even if they're making money, you can't discriminate against women to make money or avoid losing it. So, going on, where the money came from, whether it came from a big donor or for ticket sales or for tuition, doesn't matter. They say, well, wait a minute, but if we're using it as a business, doesn't that mean we can get some exception from Title IX? No. Even if you view it as a business, it doesn't matter. Schools can't discriminate to make money. They can't discriminate to avoid losing money. Neither can businesses. Schools can't discriminate because of COVID or financial pressures. Neither can businesses. The schools need to provide equal opportunities, athletic financial aid, and treatment overall. So let's talk about the big picture for a second. The big picture. Almost all college is in violation, and the only enforcement is by litigation. It's by you, the students, female and males, who have to enforce the law. Second, costs and attorneys' fees are recoverable. Third, COVID and financial pressures over the last 2 years prompted a bunch of cutbacks, but they are not, COVID and making or losing money are not valid defenses. And when the schools eliminate women's teams, what they're doing is they're pissing women off enough, frankly, that they go start looking and saying, what can I do about this? And they learn the school is already in violation. I'm going to sue under Title IX. And then I follow the litigation strategy I mapped out in the beginning. I go to the school and say, don't make me sue you, because we'll go after every aspect of the school. But to be clear, men's teams are covered too. So Clemson eliminated its male indoor track and field, outdoor track and field, and cross-country teams, primarily black male teams. When it did so, it was already offering equal opportunities to men and women to play sports. And it was discriminating against the women, denying them equal athletic financial aid and equal treatment. So we came up with a strategy that no one had ever done before. On a Friday, I sent the letter to President of Clemson saying, hi, I represent the male athletes. This had a racially discriminatory effect, but the Supreme Court has made it basically impossible to sue over race discrimination. But you've also discriminated against the men on the basis of their sex, and you're violating Title IX. Unless you put those teams back, we're going to sue you for all the discrimination against men and male athletes by depriving them equal opportunities to play. And Lori, who was with a separate firm at that time, sends on Monday a letter to the president saying, hi, I represent the women. The women athletes know about the men's threatened lawsuit, and we're supportive of them. We want you to provide equal opportunities, but we also want equal athletic financial aid and equal treatment for us. And unless you provide us that, we're going to file a class action on behalf of the female athletes and potential athletes in the school for sex discrimination against us in violation of Title IX. And literally, we made Clemson the first school in the country simultaneously threatened by both the men and the women for violating Title IX. And Clemson put back the men's teams, actually added 2 more women's teams, and agreed to give women equal athletic financial aid and equal treatment. So men's teams are covered too. Almost all women athletes and some men athletes could sue right now. They just need to be educated and willing to fight. So I want to show you the reason it's so important is because if you do fight, we can make a huge difference. These are schools that we have either successfully sued or are now suing a couple of them, or have threatened to sue and gotten teams reinstated and got the schools in compliance. An extraordinary number. We have never lost. I have, since 1980s, never lost a Title IX case because the schools are in violation, plain and simple. But you need to know your rights. If you think your school may be in violation, call and let me know. And let's just go on for a second. That's what you need to know now. But I want to say, but wait, there's more. feel like I should offer you all Ginzu knives, but I want to turn it to, we're going to talk about name, image, and likeness, and the NCAA and associations, and then questions. So let me turn it over to Carrie Joshi to talk about name, image, and likeness.
Thanks, Arthur. So one of the latest developments in college sports that has serious implications for Title IX are the new rules and regulations around NIL. And NIL is an athlete's use of their name, image, and likeness in exchange for something of value, usually money. And before July 1st, 2021, so almost a year ago now, activities like appearing in advertising or promotions or selling photographs or, tweeting endorsements were violations of the NCAA rules, and they could lead to a student athlete being declared ineligible to compete in an NCAA sanctioned college event if they were found to have violated this rule. But after the US Supreme Court signaled in Alston v. NCAA that it would support students' rights in regards to NIL should the NCAA continue to enforce a prohibition, and at the same time, after state legislatures started passing their own laws that did allow student athletes to profit from their name, image, and likeness, the NCAA had to suspend its own NIL rules. So some examples of NIL activity include accepting direct payments for promotional activities, receiving free or sponsored products or services in exchange for promotion, earning money from social media promotion, earning a portion of whatever money is made from a product, being an ambassador for a brand or a business, or straight up appearing in commercial ads or other digital content. And since the NCAA made this change almost a year ago now, I'm sure you've all seen headlines and social media posts about college athletes around the country signing up to promote everything from mortgage companies to fast food to sports apparel. For example, we've got quarterback Bo Nix from Auburn University, who is promoting here Milo's Sweet Tea. And as shown here, much of the current NIL content does appear on the athlete's Twitter or TikTok or Instagram account. A great example of that are Haley and Hannah Cavender, who were basketball players at Fresno State and recently transferred to University of Miami among much fanfare. And one of the major reasons they cited for wanting to transfer for just their senior year was that the University of Miami provided better NIL opportunities, maybe not the school itself, but the platform of the university. And then you've got Anthony Hamilton Jr. I'm a huge fan of his TikTok videos. He's a multi-sport athlete. He was actually on the Clemson track and field team that we represented, although he wasn't one of our direct clients because he was a senior and going to Chicago State University to then play basketball. And as I said, he makes some great videos here. He was promoting Rain Body Fuel, but he has a number of different NIL deals and has really profited from a social media presence that he already had, and now he can monetize it. So all of this seems like a really positive step for student athletes who have for a very long time been denied any ability to profit from their hard work and reputation in their sport while they're in college. But as perhaps we should have expected, male athletes are really reaping most of the rewards in the NIL space. And keep in mind that the statistics on this vary because this is a whole new world. There's no centralized reporting mechanism. So a lot of it is just guessing and trying to cull data from, the internet or various organizations that are also trying to gather information. But according to a recent study of college NIL deals across all three divisions, 72% of the deals are going to men and about 28% are going to women. In the slide that you're looking at now, this is showing total compensation, which closely maps deals as well, where in total across the three divisions, 77% of the NIL dollars are going to men, with just 23% going to women. And the biggest deals, as might be expected, are in Division I football in the biggest conferences. And football players, and football being a male-only sport, so men, are the recipient of 50% of all deals across the NIL space. And the closest women's sport, basketball, is only about 18.5%. And again, I want to tell you, these percentages, we're not even sure if they're accurate. There were other ones that put the football number much higher and the women's basketball number much lower. But in any case, there's a huge divide. And one of the potentially most controversial outcomes of the new NIL regulations, or lack of regulations, are what are called collectives. And collectives are groups of boosters and school supporters who put their money and resources together to provide NIL compensation for athletes at their particular school. And these collectives are being closely watched, but as of the current football recruiting season, so last year's recruiting season moving into this year's football season, there are regular conversations now among universities and coaches about how many millions of dollars in NIL deals they're going to need in order to keep these big football schools competitive. One example, the University of Tennessee just allegedly made an $8 million deal with a new freshman quarterback recruit. That's $8 million over 4 years, but going to one player. Similarly, OSU's coach has said that he believes he's going to need $13 million in NIL spending to keep his football roster, both to keep the recruits that he's brought on and those on the team from transferring. So there's clearly a huge gap between football and all other sports, but most certainly between football and women's sports. And if all of these NIL deals were kept outside the bounds of the universities where these players attend, then we might not be having this conversation on the 50th anniversary of Title IX. But common sense and history tells us that there's no separating the school from their athletes and therefore from these NIL deals. And here's the key issue. As soon as a university plays any role in helping its student athletes earn money or make deals through NIL, it is necessarily providing a benefit to those student athletes. And as Arthur just talked about, Title IX requires that male and female athletes at a school overall receive equal benefits and treatment. So if the university becomes involved, arranges or offers deals for men and not women, then it risks being out of compliance with Title IX. Some of the potential violations more concretely are, a university brings in an outside organization to train its men's basketball team in how to navigate the world of contracts and agents and that sort of thing. But they don't similarly train any women's teams, and this is happening. Another example is, we were talking about collectives. The boosters at a university want to provide NIL deals to certain recruits. They necessarily have to work with the coach to figure out who the key recruits are, right? They can't just guess on their own. They don't have the information. They don't have the potential recruit list. And so in order to target the right people, they're going to have to work closely with that coach. And so then the university is involved. Another example that our Title IX team has experienced is where a university is willing to license its logo to certain teams, men's teams and not women's teams. And so therefore the women's teams don't have the same opportunity to promote their sport and themselves using their university licensed apparel. So these are just 3 examples, and there's many more. Most schools are going to have a very hard time avoiding involvement in this NIL process. And in some states, more and more, as state legislatures look into this, have under their NIL laws requirements that the school be involved. And they see it as a way to protect students and to give the students more support when it comes to NIL. But it also means that the school is involved, and that has Title IX implications. And really, there's no separating these out. Most athletes who have the potential to profit from the use of their name, image, and likeness can do so because they play on the school's team. The university is their platform. If they were not attending a university, they would not be a part of the NIL conversation. They would just maybe be out playing their sport professionally. And so the two are intertwined, and it's going to be impossible to separate them. And the moment a sponsor or agent or collective talks with a coach or an athletic director about a deal with a recruit or a player, then the university is involved. And if the university fails to support its athletes equally in this way, then there's real potential for the violation of Title IX that requires equal treatment and benefits to its male and female athletes. So how is this going to be enforced? And unfortunately, it's the same way that Title IX in general is going to be enforced. It's going to be up to student athletes. The student athletes are the ones who are in the best position to assess what treatment and benefits are being provided across the athletic program. And they're the ones who are going to, at the end of the day, probably have to bring a case against their school for a Title IX violation for not providing equal treatment and benefits. And all of this sort of begs the question. The NCAA used to regulate this area, and it was their suspension of their regulations that has created this new space. So what are they doing, if anything, to help ensure equity in the NIL world? And as my colleague Lori Bullock will tell you, the NCAA is not doing a whole lot to help out with this issue or to support Title IX in general. And Lori, I'll turn it over to you.
Talk about it as though it's its own federal agency that is put in place to, the NCAA is put in place to monitor Title IX. As Carrie indicated, that's not true. So the NCAA governs, over 500,000 student athletes across the U.S. and Canada and Puerto Rico, and it is made up of the member colleges and universities. It's not its own administrative agency. It answers to no one within the federal government. And so it's for that reason that the NCAA is allowed to get away with a lot of the discrimination that it does. So it's important to talk about the history of the NCAA and Title IX. The NCAA has been around since the early 1900s. And in 1972, when Title IX was passed, at that point, the NCAA bylaws did not even permit women to compete in NCAA-sponsored events at all. Justin, if you can go to the next slide. So leading up to the passing of Title IX, the NCAA lobbied on multiple fronts, for the exclusion of athletics from Title IX. When that failed, they lobbied for what was called the Tower Amendment, Senator Tower, which sought to exclude revenue sports from Title IX. And the basic argument and the basic reason that the NCAA lobbied against Title IX is that they thought Title IX would be the downfall of men's sports. That if women were allowed to play college sports, that would be the end of men's sports as we know it. And the same is true of the Tower Amendment. Senator Tower's basic argument was that sports like football provided the crucial revenue for the entire athletic program of most colleges. And if Title IX stepped in and interfered with that team in the name of gender equity, then the entire athletic program would end and no one would get the chance to play. Of course, we've seen that isn't true because NCAA's lobbying efforts all failed. And athletics, as Arthur clearly explained, are included in Title IX, and there's no exception as to whether sports produce revenue or don't. So, despite the passage in 1972, the NCAA still didn't get on board with including women until 1981 for Division I sports, 1980 for Division II and Division III. That is when they started sponsoring their first championship. And they did so because they thought, well, if we can't exclude athletics, then we want to be in the business of making money off of women's sports. So the resolution to sponsor women's championships was actually introduced every year since 1976, and it didn't finally pass for Division I until 1981. It was very controversial when it did pass in the NCAA. Until that time, there was a separate entity similar to the NCAA, but different in many ways, called the Association of Intercollegiate Athletics for Women that governed all women's sports. And most colleges had a separate men's and women's athletic department. 90% of those women's athletic departments were run by women athletic directors. And they did a lot in those 10 years to progress women's athletics forward, to make up for the inequities that has existed, to build those programs to, the point where they were sustainable when they were finally folded into the NCAA. But when the NCAA started sponsoring women's championships, it became financially unfeasible for the Association of Intercollegiate Athletics for Women to continue. And those programs were merged together. When that happened, it was almost always the head of the women's department that was let go, the women's athletic department that was let go. And then all of these athletic departments, these co-ed athletic departments, were run by men. I think it's important to understand that in many ways, Title IX, as Arthur said, has helped, but having that separate athletic department for women really did a lot for women's sports. In 1972, women coached more than 90% of the women's teams in the country. In 2021, that number is only 40% of the women's teams are coached by women. So how do NCAA bylaws and Title IX intersect with each other? A lot of times the NCAA bylaws and their regulations, we find that schools use them as an excuse to violate Title IX. This can be seen the easiest and is the most prevalent in athletic financial aid. So NCAA regulations limit the number of scholarships that any individual sport can offer. And as you can see from the chart, men's football, which is by far and away the largest men's team, 100, 120 men on a men's football team, they're allotted 85 full ride scholarships. So these are all the number of scholarships at every sport. When you start to look at, larger women's teams, such as track and field and cross country, or the rowing team, the track and field cross country team, which is where the schools are finding their participation numbers to try and comply with participation requirements, they only allow 18 scholarships. And that 18 scholarships is across all of cross country, indoor, and outdoor track and field. So that might be 60 to 80 women, and they have to share 18 scholarships. The same is true of rowing, which may be 70 to 90 women on a rowing team is what the schools are purporting that they carry, and that's only 20 scholarships that the NCAA allows them to have. It's really important when you're looking at your school's financial aid numbers, which you can do on the U.S. Department of Education website. You can go and see what is the discrepancy from the year before. It's always a year behind, unfortunately, but what is the discrepancy and how much athletic scholarship they're giving to men and women. But it's important to remember that NCAA bylaws, NCAA rules and regulations never trump Title IX. Title IX is a federal law. The schools are required to comply with Title IX, and falling back on the NCAA regulations is not an excuse to violate Title IX. So, for example, what that looks like is, even though you're allowed to have 85 full ride men's scholarships in football, maybe you don't award them all unless you have a combination of women's teams, which, let's be honest, it's going to need to be a lot of women's teams that a university is carrying in order to make up that 85 and make that proportional, like Arthur talked about. If you can't do that, if the college can't do that, then they need to not award all of those scholarships. But that's not what's happening in reality. In reality, what's happening is that they're awarding the 85 scholarships and they're nowhere near complying with athletic financial aid, cheating women out of millions of dollars every year because of that noncompliance, and falling back on NCAA rules to say, there was no way we could get any better. So in addition to, being an excuse for the NCAA, for schools to violate Title IX, the NCAA in and of itself has a lot of discrimination issues. Go to the next slide. We'll see if this works. And I'm sure we've all seen this video.
I got something to show y'all. So for the NCAA March Madness, the biggest tournament in college basketball for women, this is our weight room. Let me show y'all the men's weight room. Now, when pictures of our weight room got released versus the men's, the NCAA came out with a statement saying that it wasn't money, it was space that was a problem. Let me show y'all something else. Here's our practice court, right? And then here's that weight room. And then here's all this extra space. If you aren't upset about this problem, then you're a part of it.
That was, a rare moment when the men's and women's NCAA tournaments were together. Their March Madness tournaments were together. And because of COVID and because they were together, Sedona Prince, as you saw in the video, had the opportunity to call out the NCAA and notify the world through social media that they were not being treated the same at all. And hopefully the audio came through. If not, and you haven't seen the video, go watch it. But basically, the little tiny A-frame of weights there is the entirety of the women's weight room, whereas the men's NCAA team, NCAA teams that are competing have state-of-the-art weight room, plenty of space for them to all work out. And this inequity triggered an NCAA gender equity report. Now, it's important to recognize that the gender equity report was actually done by the firm. The investigation and the report itself were done by the firm that defended Brown University in 2020 for their Title IX violations. So, the NCAA didn't necessarily bring in an unbiased outside investigation source to do this, but the investigations were still done. A two-phase study was completed. The first was just looking at the basketball championships because that is the largest championships, the most publicized championships that the NCAA sponsors. It's also the organization's largest source of revenue. And then after that was completed, to do an external gender equity review of all of the NCAA. That one, phase 2, was completed in October of 2021. So there were a number of issues identified in phase 1. There were issues with allocating significantly more resources into men's basketball than women's basketball, even taking into account the different, the size of the tournaments, the size of the, one of the excuses that was used was that there's so many more attendees for the men's games. And even taking that in consideration, the resources allocated differed significantly. There were sizable disparities between, the overall budgets. There was a common misconception that within the program itself, within the NCAA, when interviews were done, that women's basketball reports to and is subordinate to men's basketball in every capacity. The other issue that was identified as a perpetuating discrimination issue is that the NCAA only shares revenue based on the performance in the March Madness for men's basketball. So for those of you who don't know, the further a men's program makes it in the March Madness tournament, the more revenue that school's conference is given. And so institutions are incentivized to invest as much money as possible in their men's basketball program in hopes of progressing farther in the men's tournament and getting a larger chunk of the revenue from the March Madness tournament allocated to their program. There is no program in revenue sharing in women's basketball at all. And so this sends a very clear message to all of the schools, to all of the student athletes, about which sport matters and which sport does not matter. And it was very clear to the student athletes, that the female student athletes, that their sport did not matter. So the report came out, it identified a number of disparities and gave a number of recommendations. Unfortunately, many of those recommendations were not addressed. And the NCAA had every opportunity to address those. So despite the clear recommendations in the gender equity report, the NCAA really failed to make the systemic changes to address the discrimination in the programs. The changes that were made, Justin, if you could go to the next slide. The changes that were made were things like, I think, one of the captions were, when men's teams get a gift box, the women's team will get the exact same gift box. When the men have a yogurt bar, the women's teams will have a yogurt bar. When men have a pasta station, the women's teams will have a pasta station. And the men's and women's lounges will match exactly down to each of them will have 28 pillows. And the overwhelming theme of what was fixed are things that could show up on a TikTok video, things that could show up on social media. Whereas, the issues that were not addressed were the leadership structures, were the internal structures that were recommended to be put in place that would throughout time from that period going forward, address those inequities. So in phase 2, the issues that were identified, in addition to basically everything that was identified for the men's and women's basketball tournaments, was happening in every single championship that the NCAA sponsors. But, they also identified that spending was about half of the amount per student, per participant for women as it was for men. That gap was even greater in single gender sports. And again, pointing out that the organization lacks the resources and processes necessary to ensure its commitment to gender equity. And that the NCAA incentivizes structures and media contracts that contribute to men's sports being favored over women's sports, men's sports being publicized over women's sports, and perpetuates that discrimination. So in phase 2, those report recommendations were varied in many, but the big things, we can go to the next slide, Justin, were that the NCAA needs to develop clear criteria for decision-making about allocating resources. It needs to increase an internal structure that is dedicated to gender equity. It needs to, one of the recommendations were to have a committee that conducts live, real-time assessments of the championships. So it's not just an after-the-fact thought about what was equal, what was not, but while a championship is happening, have a specific committee that is going and reviewing both of them in real time and making sure that they are equitable and continuing that progress towards gender equity. So I'm going to speed up here so we have time for questions, but how do we hold the NCAA accountable to Title IX? That's the big question. There was a case in 1999 called Is the NCAA versus Smith. It was an athletics case, and the plaintiff argued a single theory that the dues paid to the NCAA were paid from member colleges and from universities that receive federal funds, and so therefore the NCAA, as a recipient of those federal funds, should be held accountable to Title IX. And what the Supreme Court said is no. Dues payments from member colleges are not sufficient to subject the NCAA to Title IX. And what that has left us with, since then, no one has challenged that holding or tried to sue the NCAA under Title IX again. At that point, the NCAA was also taking federal funding. It stopped doing that immediately to try and, eliminate any possibility that it would be held accountable under Title IX. But we're ready to try again. We're ready to go forward and hold the NCAA accountable, both for its discrimination within the championships that it sponsors and the bylaws that perpetuate discrimination at the colleges and universities. And so how we can do this is, court actions arguing new legal theories. There was a legal theory put forth in the Smith case, which was that, when these member colleges cede controlling authority over a federally funded program to another entity, that controlling entity is covered by Title IX, regardless of whether the NCAA itself. So conferences and NCAA control championship play, and its bylaws control, how athletic programs are structured. They limit financial aid, and therefore ceding that authority, that control over to the NCAA brings them into coverage by Title IX. The other way that, Congress right now is looking to hold the NCAA accountable to Title IX is legislative action, explicitly applying Title IX to the NCAA and other organizations that govern. Senator Murphy is introducing that bill as we speak on the 50th anniversary. So there are ways to hold NCAA accountable. We're ready to do that. We just need to find the right case and bring that forward. So I'm going to turn it back over to Justin for questions. And I know that we do have some questions that have come in, so we will do our best to answer those. We might go a few minutes over, but we'll try and get everybody's questions answered.
Yeah, thanks, Laura. We did get a few questions. I'll just start with one right now. I know we're coming up to the top hour, so we'll be respectful of everyone's time. But one question that I got, that we received, if I suspect that Title IX is being violated in my sports program, is there anything I could do or should do before reaching out to a lawyer to help protect my rights under Title IX?
Carrie,
Arthur, you want to take that? Carrie?
Did we lose Arthur?
Arthur, you there? Yeah, there you go.
Can you hear me?
Yes.
Yeah.
Okay. Yes, first of all, there are numbers that are public that everybody can access. The Equity and Athletic Disclosure Act, EADA, requires every school in the country to submit a report with a whole bunch of its numbers, and then they're made public on the federal government's website. So you put in EADA, and you will get to a federal government website that lets you go through your school's information, and you can look at that for more documentation. Many schools post that on their website, but you can get it through the federal government anyway. It shows participation numbers, undergraduate enrollment numbers, athletic financial aid numbers, and a whole bunch of other numbers. So that's the easiest, just quick access to it. But also, if you have any questions about it, just call us. We know how to access this information very quickly from a whole bunch of different angles. Contact me or Carrie or Lori, and we can help figure it out for you.
And the only thing I would add to that, Justin, is every college and every high school in the country is required by Title IX to have a Title IX coordinator, to have a process for fielding complaints. So learn that process, that internal grievance process, and don't be afraid to raise those Title IX issues and that discrimination that you see internally as well.
Cool. We'll do one more, at least one more. I'll ask, there's another one we got. Filing a lawsuit against my school can seem intimidating. Is there anything that protects me from retaliation or the potential embarrassment of making my school look bad?
Okay, well, I'll answer that as well if it's okay. First of all, yes, they are prohibited from retaliating against you. Title IX prohibits retaliation, bars it straight out. Most schools know that big time, and if a lawsuit is filed or even threatened, the last thing they're going to do is retaliate against you. In terms of embarrassment, no, if you're not, if you're going to be willing to stand up and fight, you're going to have to recognize it could be embarrassing, more likely for the school than you when you disclose what they're doing. All of the clients we've had have basically told us one of the things that make them feel empowered and proud is that they did stand up and fight because, like we said, they've all won. And so because the school's violating the law, and sadly, with the federal government not enforcing it, is entirely on the shoulders of the women and men athletes to make sure the school complies in terms of lawsuits, and the administrators and the parents and the alumni and the press and everyone else to push the school to do so.
Cool. Thanks, Arthur. Carrie or Lori, anything to add?
Nope, I'm good.
No.
Cool. I'll ask at least one more. You'll have to probably give a little bit of a background here, but what is one question we got in? What's the effect of Cummings versus Keller Rehab, the Supreme Court case regarding the Affordable Care Act?
Or you want to take that since I've answered the other two? You want me to go?
Sure. Yeah. So Cummings v. Keller Rehab is a recent Supreme Court case, involving the Rehabilitation Act, which is Section 504. And, as of right now, that law, that holding only applies to the Rehabilitation Act and that the disability claims that were brought in the educational side of things. And for the most part, though, the real answer is it doesn't really affect the kind of claims that we bring typically in a Title IX case. When the student athletes are filing a lawsuit, they're seeking injunctive relief, which just means they want to end the discrimination going forward. And so the Cummings decision has absolutely no bearing on a student athlete's right to fix the discrimination, to have the court step in, declare that there was discrimination, and put into place, force the university to put into place a plan to get into compliance. Where that comes, the Cummings decision may play a part is, when individuals are seeking damages. But again, it wasn't a Title IX case, and so for right now, nothing has changed in the Title IX world.
Cool. I'll just ask one more question, then we can wrap here. Final question we got in, or another question we got in, I should say, is how can I help protect student Title IX rights if I am not a student athlete, but a parent, coach, trainer, or school administrator?
Do you guys want me to take that one?
Sure.
Yeah, so we've talked a lot about how enforcement of Title IX is on the shoulders of our student athletes, but all of those other individuals can support student athletes, can help student athletes find resources to help them enforce Title IX, and just be aware and be advocates for Title IX. There's a lot of folks within the university who probably have a lot of information related to the athletics program and their treatment of the various teams. And those people are great resources for the students who end up having to bring these cases. So you can act as the supportive community for the case, even if you as an individual may not have standing to bring an actual case.
Well, and let me just add 2 points. First, in terms of Cummings, the decision held that under the Disability Act, damages for emotional distress are not recoverable. And on that case, I want you to know there's a motion to reconsider the case because it was based on a theory that the Disability Act didn't address what damages were available, when in fact it does address what damages are available. And the lawyers for the plaintiffs filed a brief with the court saying, we missed this, but so did the defendants and so did you. And actually the statute says point blank, emotional distress damages are available. The Supreme Court has not yet ruled on that motion for reconsideration. So the whole decision is up for grabs. But second, obviously in a whole lot of kinds of cases, including damages cases for being cheated out of athletic financial aid, that wouldn't matter because you're not seeking emotional distress damages, even if you are seeking damages. And then to add to Carrie's comment, I want to say, look, we are lawyers who know how to sue in court and make the schools comply with the law. But litigation is not the only avenue to make schools comply with the law. They hate public exposure. They claim publicly they want to do the right thing and they're complying. So they respond significantly, or at least can, to public exposure of the real facts, to political pressure, to PR pressure, to alumni and parent and donor pressure. Our lawsuits can make a huge difference, but it are also, all of you can make a huge difference if you organize. For example, Clemson, not only did we threaten to sue, there was a whole group of parents and alumni that had created Save Clemson cross country and track and field that had a big impact. So it is not you just hire the lawyers and we do it all, although we're happy to do as much as we can. It's that you have to fight and be visible too. If you want, you can make a huge difference.
Cool. Thanks, Arthur. That's super helpful. I'll go ahead and wrap up. So just want to thank everyone for attending. We hope you found this insightful. On behalf of Arthur, Carrie, and Lloyd, we just want to thank you as well. And hope you have a great day. And feel free and do get in contact with us if you have any questions. We'd be happy to be of further assistance. Thanks all. Bye now.